Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Real Estate Group, and today we're joined by our host Jim York and his guest, attorney Anthony Cetrangelo.
Thank you, Morgan, for the introduction. Well, Anthony, thank you for coming on the show today.
Oh, thank you.
So let's just tell us a little about yourself.
Well, first of all, thank you for having me on the show today, Jim. Well, originally I'm from New York, the Long Island area. I ended up going to college in Alabama at Troy University, where I played Division I college football as a kicker. After that, I ended up going to law school locally here in the Vineyards at Ave Maria School of Law. And now I'm an attorney, and I own the law firm Threlkeld and Cetrangelo with my partner Joel Threlkeld. And we practice real estate law, probate, wills, trusts, and estates, business law, immigration. And it's been excellent since opening up the firm. And we're located around Greek Gourmet down by the courthouse.
Well, that's good. And it's so I thought you said maybe you have an office in Bonita too?
Yes, we just recently opened one up there, and we're looking to open up one in Lely later this year also.
Okay. Well, Anthony, we're here today to talk about domicile, trust, and probate.
Yes.
So let's start a little bit about domicile.
All right. So, in the state of Florida, there's a lot of benefits to when you establish your permanent residence here, such as no income taxes, strong creditor protections, homestead tax exemptions, and if you have children that are going to go to college here, maybe even some in-state college tuition. So, in order to establish your domicile here in Florida, the first thing you typically want to do is file a declaration of domicile with the clerk. It's a fairly easy process. Fill out the application, have it notarized, and then have it filed. But there's more to it than that. That's just the first step. So you also, if you own real property here, you're going to want to file a claim for homestead tax exemptions. If you also want to file a termination of your non-Florida domicile. And then the way the court and taxing authorities like the IRS look at it is it's on a subjective scale. So they're going to want to see some more things besides what I just previously mentioned. So first of all, you're going to want to spend the majority of your time in Florida. You're going to want to get a Florida driver's license, a Florida voter's registration, vehicle registration also, and any bank accounts that you have in your previous state, such as your checking, savings, investment accounts. You're going to want to switch them over to Florida. And then your wills, trusts, all your estate planning stuff, your healthcare surrogates, your durable power of attorneys, you're going to want them to recite that you are a resident of Florida. See, all of that encompassed together will show your intent that you are domiciled in Florida permanently.
And to file all this stuff, do you need an attorney or can you do it yourself?
You can use an attorney. I don't think it would be very hard for you to do, though. Just go online to call your clerk and download the form and fill it out and have it notarized, and then it's pretty much it.
It's a standard form, probably.
Yeah, standard form.
And how soon would somebody have to do that after coming down here, or should they be here a period of time, or can they immediately do that? Do they have to own property here?
You don't have to own property here, but it would be smart to do it as soon as possible, just to start showing the intent that this is going to be your permanent abode.
Okay, so they don't have to necessarily own property here, but they wouldn't not have to. Could they own property in another state and still not own property here and do it?
Yes, you could. But if you own property in another state, since it's an intent factor that we're looking at, you may want to rent out that property to show that that's not your permanent abode and that you're looking for property here. Also, by putting it on the market and attempting to sell it, shows that you're transitioning to this state as your permanent residence.
How about if you're a husband and wife, can one file and one not?
Well, there's special, that's a good question. I've had that before. There's special situation for that the courts will look at. They'll look at if there's any fraud in there, and that if they're truly separated for some reason, and that say one's doing business in one state and the other one is doing business in another state, and they have to be split up for that time period, then the courts may look at that. But it's it's a gray area.
Okay. Well, Anthony, we're going to take a little short break here, and we're going to come back and talk about probate, right?
Yes.
Okay. We'll be right back. Thank you.
Thinking of buying or selling a home in Naples, Bonita Springs, or Estero? Think of the most experienced realtors. The York Real Estate Group of Downing Fry Realty. Let's have a look at what the McLeans have to say about their experience working with the York Real Estate Group.
Jim York was our broker in acquiring our present home in Bonita Springs. His knowledge and integrity made the process go very smoothly.
It was a pleasure doing business with Jim York. Everything was done in a superbly professional manner.
Welcome back. What's probate?
All right, so probate, it's the legal process where the court supervises the distribution of your estate and makes sure that your will is legally valid. And by estate, I mean real property, your bank accounts, everything that encompasses your estate pretty much when you pass away. So the court will look at your will to make sure it was executed correctly and that it's valid. And then the process starts where your debts are paid and the creditors are paid. Your assets are then distributed according to your will. And if you don't have a will, then it's distributed according to the Florida intestate succession laws. And then, depending on if you had a will or not, the court will have to appoint an executor of your estate. But if you have a will, then it's already appointed according to your wishes.
So, so you have a will. Okay, and your husband, wife. So the will usually passes down to your wife or whoever the survivor is, right?
Correct.
Okay, so and they would pay off. Do you have to go through probate if one of the other spouse is surviving or not?
Oh, usually when the spouse is surviving, the property is titled to the both of them, and you don't have to go through probate. Now, the issue comes up when the wife also passes away, or the husband, whoever passes away last. A common misconception that I have with a lot of clients that come in the office is that the will doesn't have to go through probate, but it does.
It does.
It does.
Okay, and what is the procedure for that? I mean, what do we do? We both died, and my kids have a will. What do they do when they come and ask you?
That's a good question. So, the kids typically will come into a probate attorney's office, and they'll give them the will. The attorney will then file the will, and then the process begins. Depending on whether or not, or how much money you have in your estate, you can have a summary administration done or a formal administration. Now, the summary is a little bit quicker than the formal administration, but it's still a very lengthy process, around 6 months to a year to get it finished. So petitions are drawn up, they're filed with the court, and then notice to creditors is ran in the newspapers, where creditors have 3 months to put in a statement of claim on your estate. And then after that, the creditors are paid, and then the judge will look over the case and hopefully sign the orders for your assets to be distributed.
And let's say a person has a mortgage on their house. Does that have to be sold, or can they continue to pay the mortgage?
So typically the mortgage will be continued to be paid by the children. And then, it's really their call whether they want to continue paying it after everything is settled. There might not be enough equity in it. The house may be underwater. It's the family's decision after that.
Okay, so how do we avoid probate?
So the best way to avoid probate is to get a living trust.
Right.
Now, the issue with probate is, first of all, that there's a lot of frozen, your assets are frozen for all those months until the orders come out. Also, there's a loss of privacy with the will because it's public information at that point. Now, to avoid these issues, you will get the living trust on, which it's a legal document that gives instructions on what to do upon your death. And then the trustee that you appoint holds legal title for your beneficiaries. So those assets at that point no longer become a probate asset, and they don't have to go through the whole court process with the judge's supervision. So the best way to do it is to set up a living trust, and initially you are the trustee of it. because it's a living trust, you
Right.
don't lose control of your assets.
That's right.
You can do anything you want. If you want to buy more property and add it in there, you can. If you want to make some investments with whatever brokerage accounts you want to, you can put them into your trust. If you want to sell your property, you can sell it with no problem. It's all amendable during your life. So it's an excellent tool for having full control of your estate and avoiding the probate process.
Is this for wealthy people or just common people, or does it matter?
You know, that's another great question. I get that a lot. If you own real property, you know, it's a great tool to transfer via quitclaim deed your property into your trust, keep it out of probate in the lengthy process, and to get the property to your children or beneficiaries as fast as you want. So it's not just for wealthy people, it's for people that own properties.
And would you start off with doing a will first when both people are alive, or would you just go to the living trust right from that point?
So when you get a living trust done, a pour-over will typically accompanies it. So pour-over will is a little bit different than a regular last will and testament. It basically is a catch-all for any property that you accumulate that you don't put into the trust, fund the trust right away. For example, say that you have 3 homes, right? And we funded them all into the trust. Now you acquire another home, but you didn't get to your attorney in time to fund the trust. Now that property will be subject to probate because it wasn't funded into the trust. Remember, the trust only has control of what you fund it with.
Right.
Okay, so the pour-over will that comes with the trust will catch that property, put it through probate, and then send it into the correct distribution that you have in your trust. So yes, a will does come with the package that we typically do, and it's a great tool for catching anything that wasn't funded.
Okay. Well, we're going to take a little short break here, and we're going to come back talk about trust itself, right?
Yes.
Okay, we'll be right back. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Well, Anthony, let's continue our conversation about living trusts. So tell us what advantages are of living trusts.
Yeah, so you know, the living trust, like I said earlier, helps you avoid probate, right? So then you're not subject to the court's supervision, and your assets stay out of the mix of court, right? So your children and beneficiaries, it's customized. Whoever you want to elect to receive your property can receive it fairly quickly. So, you know, no probate is needed. It's less expensive than a probate also to get a trust on typically. Some attorneys will charge 3% of the gross estate in some circumstances, and if you have a large $1 million estate, you can see that it can get pretty expensive.
That's right.
Now, your property is not subject to those fees if they're in a trust because it's a non-probate asset at that point. So that's another advantage over the wills too. Also, with the will, of course, you know, it takes 6 to 12 months to get those orders and for your kids to get the property. Now, the issue is if your property, such as a bank account, is locked up in probate and it's frozen, the kids may need access to that money to pay for funeral expenses, to help keep up with the mortgage, and anything that's accruing, any bills. So
if you give them power of attorney, does that help or not?
Now, the power of attorney helps while you are living, but it's once you pass away, it's terminated.
It's terminated.
Right.
Okay.
So this is where the trust comes in. When you elect a trustee, after you pass away, it's called the successor trustee. Your successor trustee has a fiduciary duty to uphold to you. He has to follow your instructions that you left in the trust. It's also a legal duty. So they're kept in line. If the beneficiaries want to bring them to court to follow the instructions, they can. So it's safe, the living trust, and making sure that your intent is carried out. And on top of that, it's all private.
Okay. So going into the next session here, where would we go from here?
So basically, the next question I get is, I have a homesteaded property. Can I put my property into the trust? Well, federal law allows you to put your property into the trust even if you have a mortgage. And then all you have to do to update your homestead is go to the property appraiser with your trust and your license, and they will update it so that you get the tax exemptions. So the trust doesn't mess up anything. It is still your property fully to manage and control. And the only thing that changes is when you pass away, the trust becomes irrevocable, and then your trustee has to follow your instructions. So it's a great tool.
So they don't have to pay doc stamps on the deed or anything. It's a filing fee.
Right. Not in this case, because it's still your asset. You're the initial trustee. Now it's around $19.20 typically to get it transferred into the trust. The other thing is that there's some tips that I would give to people that don't have wills or trusts set up right now.
Is that a high percentage of people, do you think?
A lot. And half of my practice that I do is probate.
Right.
So I see a lot of people come in that have problems that could have been easily avoided had they called me, a month earlier.
Right.
And it's very simple advice. So for example, I see a lot of checking accounts and savings accounts, sometimes $20,000, $30,000 in there that are frozen. The husband passes away and then the wife passes away. Now, obviously the wife had full access to the account when the husband passed away, but she wasn't thinking about what would happen when she passes away. Now the kids come into me and they're like, my mom had $30,000 in this account and the bank won't give me access to it.
Right.
So it takes months and months to finally get that money out. And the kids sometimes are like, I need to pay for funeral expenses, I have these bills that have to be paid, and all that could have been avoided just by talking to the bank and putting a beneficiary on the account, such as to my 2 children. Another way to do it is to put your trust as the beneficiary of the account. That way, when you pass away, your assets go into the trust and then they're distributed accordingly. So those are some common mistakes that I see that can easily be avoided. Another one is that people will try and put their children on their deed while they're alive in order to avoid the probate process. Now that can pose some issues, because what if you want to sell your house? Now you're subject to the permission of your children to sell the house, right? So one way to get around that is by putting the property into the trust. Your children will get the property just as you intended, but during your lifetime, the property is yours to control. You don't have to ask for permission to sell the house and have them sign the deeds. So it's just, the trust is such a great tool to get around that, and it's very beneficial for real estate needs.
In the cost of doing this, or does it range from depending on how big the estate is?
A trust, it can range depending how complex it is. Typically with our packages, you get a deed automatically transferred into the trust at no charge. And then it costs just a few $1,000s in most cases to get one done.
And if they want to come in and talk to you about what their options are, how would they get a hold of you?
You could just come into my law firm. I offer free consultation, so just come on in, have a cup of coffee with me. We'll discuss any questions that you have and any issues that you think may need to be resolved, and we will look over what's the best method of doing an estate plan for you.
Great. Well, Anthony, thanks for coming on the show. I've learned a lot today, and I'm sure our viewers have, and I hope you come back on the show and give us an update, as laws always are changing, right?
That's right.
Okay.
Well, thank you so much, Jim.
Thank you. Thank you.
Thank you.